to the Probate Law Group show. I'm Michael Koberlein, coming from Mesa, Arizona today, and we will be discussing the issue of if your trustee is causing problems, then what can you do about it? Well, first of all, in order to know what I'm talking about, we should probably discuss some of the basics about a trust. A trust, as you may know, is a contract that controls property over time, and a trust has three parties. One party is the grantor, another party is the trustee, and another party is the beneficiary or the beneficiaries. So the grantor is the individual who creates the trust. The trustee is the individual who governs or controls the trust, and the beneficiary is the one who benefits from the assets in the trust. Today we're talking about trustees, and in particular when there's a situation where you have a trustee who's been appointed, but also another trustee that's been appointed. So we refer to those as co-trustees, individuals who have been appointed to govern and control the trust at the same time. Now, if those two people get along, then there's no issues. But if for some reason there's conflict between those two co-trustees, then that can present a problem. What do co-trustees do when they cannot get along with each other? Well, they can continue to try to administer the trust estate. If they can't reach a unanimous decision in their administration of the estate, then they can act according to a majority under, I'm looking at Arizona Revised Statute Section 14-10-703. Sometimes the authority to act in the name of the grantor is given to the co-trustees to act together jointly. So if there's not a majority or if there's not authority that's given to one trustee as opposed to them acting jointly, authorized jointly, then that would not be considered a situation where a majority would rule. You have to have a joint decision. One option, if you're co-trustees with joint authority or joint decision-making power, is that one of the trustees can withdraw. Under Arizona Revised Statutes Section 14-10-705, if there's one of the trustees that is willing to resign as opposed to continuing to battle it out with the other trustee, then they can do that. They have the option to do that. Another option is to request other trustee withdraw or request other trustees. There can be several. It doesn't just have to be two. If one of the individual trustees does not want to give up their appointment, they can ask other trustees to withdraw. And under Arizona Revised Statute Section 14-10-706, a trustee has the power to request the removal of a co-trustee in the event of a material breach of trust, lack of cooperation, or unfitness. So if it's not just a situation where the co-trustees aren't getting along, but there's some kind of breach of the statute, the relevant statute here, 14-10-706, then the trustee who is not in the wrong can request removal of the trustee who has been in the wrong. Option 3, which I've done in the past with some clients, you can appoint a third-party trustee. Now, oftentimes, if it's a situation where the trustees in the trust are just, there's no possible circumstance where they're going to get along, and it's just clear that there's going to be a big fight for years, it's a good idea to at least consider a third-party successor trustee. This is a way to save money and time in the administration of the trust estate. So the way it works is you find an unbiased third party. There's professional trustees and fiduciaries that do this kind of work, and this allows the co-trustees to reach a joint decision because of the conflicts and contentions that arise as a result of their dealings with the trust estate. This allows the third party to be authorized to act as the trustee, and the co-trustees that were in the position of power resign from that position and allow the third-party trustee to take control. Sometimes in that documentation, the trustees will want to reserve the right to come back into power or to be reappointed if they aren't happy with the third-party successor trustees' dealings. And if that's the case, that we can draft that in a way that allows for co-trustees to be able to hold on to that right to be reappointed if they wish. I do not recommend option 4. Option 4 is to let the conflict continue. The only people who win if the conflict continues are the attorneys. The attorneys get paid more because it's more time that has to be spent in order to resolve the situations that are in the estate that are causing conflict. If that's the case, and the parties that are involved in the estate want to continue to fight, that's a unfortunate situation, because what happens typically is the fights go on for several years. They may never stop until the estate is no longer has any assets, because all of the assets have been liquidated to pay the attorneys. If that sounds like a good situation to anybody, then it must mean that you don't really care about the assets that are in the estate, or perhaps you care about fighting with whoever it is that is in conflict with you more than you want to receive your inheritance. Bottom line, if you fight, it's almost always more expensive. So it's a good idea to resolve conflicts without going into court and causing more costs to ratchet up than are necessary. I'm just going to show you on our website. We have a screen there that you can view, and I basically went through with you the steps that are written in our article online. So if you want to review these in writing, that's where you can find them. And if you have any questions, or you have any concerns about situations with a trustee, co-trustee type situation, or even if you're a trustee and you have questions about the administration of a trust, you can certainly call us at Probate Law Group, 480-535-8000, and we would be glad to answer your questions. Certainly can sit down with you and have an initial consultation. Initial consultations are free here at Probate Law Group. And once again, thank you for spending some time watching this video.